Let's jump right into this explainer. Welcome, law students and neophyte lawyers. Today we're unpacking a truly landmark ruling, MCC Industrial Sales Corporation versus Ssyanyong Corporation, GR number 170633. This one is an absolute must-know for your evidence and obligations and contracts classes because it perfectly bridges that tricky gap between our traditional rules of court and the Electronic Commerce Act of 2000. It's literally where the paper-based world of fax machines collides with modern digital evidence laws.
To give you a structured breakdown, our agenda today follows the Socratic method. We'll track the facts, dissect the core legal issues, examine the court's ruling on electronic evidence and breach of contract, and finally, we'll cement the enshrined doctrine. First up, the facts. Let's look at exactly how this transnational deal went sour.
So, our story kicks off with a multi-million-dollar steel transaction negotiated almost entirely over phone lines and fax machines back in the year 2000. On one side, we've got the buyer, MCC Industrial Sales Corporation, a domestic corporation here in the Philippines. On the other side, the supplier, Ssanyong Corporation, a South Korean international trading company with a Makati office. In April 2000, Ssyanyong and MCC agreed via fax to an initial order of 220 metric tons of hot-rolled stainless steel. The standard practice? Pretty simple. Ssyanyong faxes a pro forma invoice, MCC's manager signs the conforme portion and faxes it right back. By June, the steel was ready, and Ssyanyong demanded MCC open a letter of credit, or LC. But MCC was having some credit issues, so the order was split in half. Come August, MCC finally opens an LC for the first half and gets their steel. But they completely failed to open the LC for the remaining balance. By September, after a bunch of extensions and ignored demands, Ssyanyong cancels the whole contract and sues for breach and damages. Moving to the core legal issues, when Ssyanyong sued, the absence of original documents pushed the Supreme Court to look at two critical checkpoints.
The first checkpoint is heavily procedural. Are photocopies of ordinary fax transmissions admissible as electronic evidence under the E-Commerce Act of 2000? This is where the evidentiary rules get super tricky. We have to ask, is an ordinary fax machine really part of the paperless digital age under Philippine law, or is it still bound by those traditional strict rules of evidence? And the second checkpoint is substantive. Was there a perfected contract of sale, and did MCC actually breach it by failing to open that letter of credit? Basically, if the court throws out the photocopies of the faxes, can Ssyanyong still prove a contract even existed, let alone that it was violated?
Let's get into the ruling on electronic evidence. The court really had to engage in some deep statutory construction here. To understand the court's logic, we need to compare these two mediums. On one side, you have an electronic data message. This is meant for paperless digital origins. Think computer files, emails, or a computer sending a file directly to a fax machine. On the other side, you have an ordinary facsimile transmission. This relies entirely on a physical paper original being scanned, sent over a phone line, and then spitting out a physical paper copy at the receiver's end. It's inherently paper-based at both ends. See the difference? And to confirm this interpretation, the court looked straight to legislative intent, specifically citing this brilliant deliberation by the late Senator Miriam Defensor Santiago. When drafting the E-Commerce Act, the Senate based it heavily on the UNCTRL model law, but they purposefully deleted a phrase that explicitly included faxes. Senator Santiago stated right on the Senate floor that the Philippine law would not apply to telexes or faxes except computer-generated faxes. The law was designed to facilitate purely paperless transactions. So because an ordinary fax transmission involves an original paper document making a paper copy, it just doesn't fit the definition. So here is the absolutely crucial takeaway. Photocopies of ordinary fax transmissions are not electronic evidence. Because a fax isn't an electronic document, it is not the functional equivalent of an original under the rules on electronic evidence. That means Ssyanyong's photocopies were merely secondary evidence. And, as you know from the best evidence rule, to present secondary evidence, they had to prove the loss or destruction of the original paper documents without bad faith. They couldn't explain why the originals were missing, so boom, the Supreme Court ruled the photocopies of those key invoices were completely inadmissible. Let's move to the ruling on breach and damages. How did Ssyanyong actually prove their case without those faxes? Now, you might be thinking, well, excluding those faxes totally destroyed Ssyanyong's case, right? Without written invoices, how on earth do you prove the contract? But remember, a contract of sale is consensual. It's perfected by mere consent. Using a preponderance of evidence, the Supreme Court ruled that the conduct of the parties undeniably proved a contract existed and was breached. Look at the facts.
MCC actually opened a letter of credit for half the transaction, accepted the delivery, and paid for it. Plus, they sent letters asking for time extensions to pay, which were admitted into evidence. And get this, several other certified invoices were admitted simply because MCC's lawyers didn't object to them. The court made a totally logical point. Why would MCC open a letter of credit for the second half of a transaction if there was no first half to begin with? Their actions showed a binding obligation, and by failing to open the LC for the balance, MCC definitely breached it.
But what about damages? Ssyanyong claimed over $90,000 in actual damages, arguing they had to resell that abandoned steel at a massive loss. But here's the catch. Actual damages can't be presumed. You have to prove them with absolute certainty. Notice the discrepancy in the evidence here. We have one exhibit showing what MCC ordered, and another exhibit showing the contract Ssyanyong used to prove they resold the steel. Look closely at those specs. The dimensions and the total volume of the steel resold didn't actually match what MCC originally ordered.
Because Ssyanyong couldn't definitively prove the resold items were the exact same ones MCC ordered, the court struck down the actual damages. Instead, they awarded 200,000 pesos in nominal damages. You award nominal damages when a legal right is technically violated, which MCC absolutely did by reneging on the deal, and that right needs to be vindicated, even if you can't prove the actual financial loss with absolute certainty. The court also upheld the attorney's fees, since MCC's stubborn refusal to pay forced Ssyanyong into litigation in the first place. Finally, the enshrined doctrine. What's the ultimate takeaway here for your legal practice? You absolutely must commit this doctrine to memory. Under the Electronic Commerce Act of 2000, the terms electronic data message and electronic document strictly exclude ordinary facsimile transmissions. Because an ordinary fax is paper-based at origin and paper-based at receipt, it just isn't part of the paperless environment the law wants to protect. It is not the functional equivalent of an original document under the best evidence rule. So, if you're ever relying on faxes in future litigation, remember that those photocopies are at the total mercy of the best evidence rule. You either present the original thermal paper fax, or you flawlessly prove its loss without bad faith. As we wrap up this case digest, I want to leave you with a provocative thought to ponder for your future practice. If the Supreme Court strictly excluded fax machines for being paper-based at origin, how will this exact same logic dictate the admissibility of the screenshots you capture on your smartphone today? Think about those WhatsApp, Signal, or Viber messages. A screenshot is just a picture of an electronic data message. It's not the message itself. So how are you going to navigate the best evidence rule with that in the modern courtroom? Something to chew on as you study your rules on electronic evidence. Thanks for joining me for this explainer, and keep digging into the law.